Good morning, everyone. We'll be starting in about a minute or two. Let's wait for everybody to get in. Okay, Steve, are you ready? Perfect. Good morning or good afternoon now. It's 12:02. Today's February 18th, 2021. On behalf of the Florida Bar Tax Section, I welcome all of you to today's presentation titled Battle of the Records in Florida Tax Audits by Steve Hogan. Steve is a shareholder in Osley McMullen out of Tallahassee, Florida. Steve is also a director of our large in the Florida Bar Tax Section and has served multiple director roles throughout the years. Steve practices primarily in the areas of tax, trust and estates, and commercial litigation. We ask that during today's presentation that you stay muted at all times. If you have any questions for Steve during the presentation, make sure to include it in the Zoom chat feature. Time permitting, Steve will cover questions during or after the presentation. The course code, I will be posting it in the chat and it will be emailed to all of you at the end of the presentation as well. Without further ado, Steve, please take over.
Thank you. I appreciate that intro, and I appreciate everybody taking some time here today. Before I get into anything, I'm going to attempt to share screen. So let's see how this goes. Okay. All right. Did that work?
It did.
Okay, wonderful. All right. Thank you, everybody, for joining us here today. Again, my name is Stephen Hogan. I'm with the Osley McMullen Law Firm. We're in Tallahassee. Just looking at the names of the folks who signed up, I know a lot of you I don't know. So I look forward to getting to know more of you at tax section meetings once we can finally meet again. So thank you for taking some time to hang with us virtually here today. Today we're going to talk about Florida tax audits, and that's audits by the Florida Department of Revenue against Florida taxpayers. And as if you practice in this area, you know that most of those audits are against businesses, not individuals. So we're going to talk about one aspect of Florida tax audits of businesses that, at least in my practice, I've found to become very important in recent years, and that is what I'm calling the battle of the records. Okay. And before we get into this, I do want to let you know that I do have this PowerPoint that I'd be happy to email you. My email address is right there, so feel free to email me for a copy of the presentation. I'll be happy to send it to you if you find this useful. Okay. And if you practice in this area, I think this will be a very useful topic for you because this is an area of law that is not necessarily obvious unless you really dig into it. So what are we talking about here today? Well, we're talking about why records matter. And everything we're discussing here today is set forth in more detail, if you will, in the Florida Bar Journal article that was published last year in the July-August issue of the Florida Bar Journal. And if you get the PDF from me, that's a live link. So you could click through to it and see that article. But if you look at the Florida Bar Journal's, the Florida Bar Journal issues that are available online, they're easy to search, so it should be easy for you to find. My my bio at ausley.com also has this listed as a link if you want to look at it there. So this is essentially an overview of what's in that article, okay? So specifically, here's the outline of what we're going to do today. So we're going to do an overview of what is a Florida audit, and that seems basic, but you kind of got to go back to first principles to even talk about why this stuff matters. And the meat of this issue is in estimates and sampling. We're going to talk about estimates and what those mean, and sampling and what that means in an audit. And it's important because, and we'll get into this more in more detail as we go, but with an estimate, you have a taxpayer being assessed based on something other than their records. You heard that right. If the department does an estimate, you have a taxpayer that's assessed tax that it may be liable for if they don't challenge it in time. If it becomes a final assessment and isn't challenged, and you end up with a liability that isn't based on anything in the taxpayer's actual records. That's why estimates are critical. And we're also going to talk about sampling because it's hand in hand with estimates. And sampling can either work in the taxpayer's favor or work against the taxpayer, depending on what the details are. So we're going to talk about that. And why this really matters is what happens when the rules aren't followed. If the Department of Revenue, for whatever reason, has an auditor that does that creates, let's just take an estimate, if you will, that proposes an assessment based on an estimate and doesn't follow the rules correctly, then what you've got is an assessment that is vulnerable to challenge on that basis, because effectively the auditor would have made an assessment in a way that does not comply with the Florida statutes, and that's a big problem. Okay, so we're going to talk about that a little bit. And as was said at the top, we'll leave some time at the end for some Q&A, so please type it in the chat. I'm not monitoring the chat, but we'll go back through it at the end. Okay. All right. There we go. Okay. Why records matter? Okay. Records dictate the result of an audit, and we've I previewed this already in what I just said, but let's talk about estimates here. A guesstimate of liability. Okay, it's not an actual liability; it's a guesstimate. I did not create that word. That word comes from a 5th DCA case called Lloyd Enterprises that we'll talk about later on in this presentation, where the judge, in some very forceful language, effectively says that in the department's power to estimate is the power to assess tax based on a guesstimate of what the taxpayer may or may not owe, and that's important. That can be a problem. In a sampling, the issue in that is that all the records of the taxpayer are not examined. Now, that can work in favor of the taxpayer, like we said, and against the taxpayer, like we said, and we'll get into those details as we go. So let's talk about audits. Excuse me. So a Florida audit overview. Let's talk about the department's audit authority. And of course, the Department of Revenue did not, descend fully created from heaven. So we have a statutory system that dictates how the department operates and what the DOR's authority to audit is based on. So the department's audit authority, you can find it in the statute there, 21334. I don't make a habit of reading text on a PowerPoint during a presentation, but you have it there. What I want to highlight is that that text in red at the top, that the department has the authority to audit and examine the accounts, books, or records. So the very basis, the very foundation of an audit is the accounts, the books, and the records. So we're talking about records. That's why this is the battle of the records. That's where everything starts. Now, we all know that if we get into battles about legal issues of this or that and the other, then we're up in the stratosphere. But that's not where an audit starts. An audit starts on the ground, where you're dealing with what records does the taxpayer have and what story does it tell. And what's the purpose of this? It's for the purpose of ascertaining the correctness of the taxpayer's returns when they file them, or to make an assessment where no return has been made, or when to assess or audit people that should have filed a return and have not. Okay, so it's facially apparent what it means that the department can audit taxpayers that have filed a return, but it's not facially obvious about how would they know who they're auditing, who had to file a return and when they didn't. And this comes up with businesses. We're talking about businesses, not individuals, of course. Businesses that, let's say, back in the days when Wayfair didn't rule the land, but Quill ruled the land, you would have remote sellers that ship things into Florida to sell to Florida residents, and did not think that they had nexus with the state of Florida, so they wouldn't have filed a return. Well, the department nevertheless has statutory authority to audit such companies to see if they actually did have nexus with the state of Florida and mistakenly didn't file a return or purposely didn't file a return. That's an example. Another example that's been a bit prevalent, a bit prevalent in recent years is the Department of Revenue searching through property records to see where you have an owner of an underlying land that is not the same as the occupant of the land, okay? And for those cases where that exists and the department doesn't have any evidence of the landlord, the owner of the underlying real property, filing a commercial rental tax return. So the basis of the department to audit such situations where commercial rental tax might be due is that statute, okay? And we'll talk more about that issue as we go. So again, what's an audit? We're examining records to determine compliance with tax laws. And the statute goes on to say that the department may inspect such books and records to ascertain such compliance, okay? Provided the department isn't time barred from making an assessment under the statute of limitations, which is normally 3 years. So let's talk about the taxpayer's record-keeping duty. Before we're talking about the department's ability to audit, now we're talking about the taxpayer's corresponding duty to keep records. Now, that's a statutory requirement as well. And this is really where we're getting into the meat of it, okay? Because it's one thing to say the department has the authority under the statutes to audit books and records. It's another thing to when we get into, all right, so what does the taxpayer have to keep? What are these books and records that the department gets to audit? Well, for that, we have this statutory definition, which is really no help at all with regard to a specific answer to that question. Because the statute says, and again, I'm not reading statutes to you, you can see it, it's that the taxpayer has the responsibility to keep suitable books and records, and to preserve them within the statute of limitations period, okay? So we have a taxpayer, whether a taxpayer is filing a return or a taxpayer that should have filed a return, they have a duty to keep suitable records for the statute of limitations period, okay? And again, normally 3 years. Of course, if a return isn't filed, that statute doesn't start to run. That's another question, okay? But what in the world does suitable records mean? Okay, if you're a lawyer looking at that statute and say, all right, my client, the taxpayer, has to keep suitable records. What are suitable records? Are they records wearing a suit? Are they records in a suitcase? No. In fact, the Florida Administrative Code, which we're dealing with here, doesn't use the term suitable records, which is, always interesting when the rules don't use the same words that the statute does. But such is life. So the Florida Administrative Code uses the term adequate records for the same purpose. Okay, so we're talking about adequate records. So this term adequate records, and the citation is there for you if you want to go back and check my work. And by the way, if anybody goes through this presentation and finds that I've miscited something, please tell me. I really do like to know that, because nobody is perfect in this land that we live in, and I always want to make it better. So if I mistyped a citation, please do tell me. I will not be offended. I will be grateful. I've always remembered the people that have cared enough about whatever I was writing or speaking on to tell me when I got something wrong. You know, most people shrug their shoulders and say, well, that guy missed that. Okay, so I really do appreciate it. Now, back to the story here. So adequate records is defined as, like we say here, books, accounts, and other records sufficient to permit a reliable determination of what's due. What does that mean? Well, let's keep going with our definitions, because when we talk about sufficient to permit a reliable determination, we have a four-pronged description in the Florida Administrative Code about what sufficient to permit a reliable determination is for the term adequate records, which means suitable records under the statute, okay? And such records must be accurate, inclusive, authentic, and systematic. Accurate, inclusive, authentic, and systematic. Obvious, right? I don't think so. I mean, when I read those terms, it's almost like flashing back to law school and sitting in constitutional law and having some professor talk to me about the difference between deference standards in the U.S. Supreme Court, which was always aggravating, because the next case that they went into was like, well, now it's a different deference standard. Now it's a different deference standard or standard of review or whatever, and it drove me nuts because they are not concrete. Okay. So what's material error in accuracy? What's inclusive there? I mean, what's authentic? What's a measure of inauthenticity? What's systematic? What's a measure of non-systematicity, if that's even a word? So my solution to this, and my take, is that the adequacy of records under the rule standard is that it's a directional rule. Okay, it's a directional rule. When I say directional rule, I mean it's pointing you in the direction, of what it means for records to be adequate. Okay, and we all know, if you practice tax law in any particular field, you're going to see businesses of all types. You're going to see businesses that do different things, that keep records different ways, and that have different circumstances for what they're dealing with. And what that means is the facts of any particular individual taxpayer are going to be different from the next taxpayer. Taxpayers don't all use the same accounting systems. They don't have their general ledgers marked the same way. I mean, stuff is different. So when you're talking about the adequacy of records under the statutes, what you're really talking about is you want it to be good enough for an audit to take place. And down at the bottom of this slide, that is a quote from the Florida Bar Journal article that I referenced earlier, that it's a qualitative standard. So there's a qualitative nature to the standards, and that means that reasonable minds can differ as to whether a particular taxpayer's records are adequate. Now, the lawyer in all of you, there should be alarms going off, because if reasonable minds can differ, that means that you might have a fight on your hands during an audit or after an audit as to whether or not a particular taxpayer's records were adequate under the rule. And why does that matter? It matters for estimates, and it matters for sampling, and it matters for the validity of the audit assessment itself if one comes out. Okay, so that's why I'm belaboring this. All right, so let's talk about one specific aspect of this, and that is whether or not records need to be electronic. Okay, so as you can see there, must adequate records be electronic? No, they do not. There is no requirement that records be kept electronically. This is critical. This is critical. Why is it critical? Well, you see what the administrative code there says. You see that it says that a taxpayer that keeps its records physically cannot be forced to, cannot be prevented from showing compliance with the tax laws by those physical records. And it is very important now, and I find myself falling into this category myself, where it's almost like things have shifted over time, where it used to be that the physical record, the piece of paper that you're holding, the thing, like that was the real record. That was the real thing, okay? Now, I mean, the physical record, I mean, I tend to feel like this is faker than the real record or than the electronic record. Like the electronic record is the real thing because the electronic record is the one from which I can print infinite physical copies. All right. So I find myself falling into that category a lot when it comes to just dealing with records in general. But and if I'm falling into that category, auditors are falling into that category too. It's almost like there's a physical record, some auditors don't want to look at it. And that is completely understandable because of human nature and how we act these days. But you've got to know that if there are physical records and they're not kept electronically, they don't have to be made electronic, okay? On the flip side, if the taxpayer keeps its record electronically, you got to provide them that way, okay? So you got the administrative code provision that's cited there. So if you keep them in machine sensible and hard copy formats, machine sensible, take that to mean electronic, then you have to give them to the department in the electronic version. You can't say, yes, I've got the electronic stuff and I've got the physical stuff. And you know what, department, here, have the physical one. You can't look at the electronic one. That ain't gonna fly, okay? But if all you have is the physical records, you don't have a duty as a taxpayer to make them into electronic records. So if you've got a bunch of electronic records, you do not have a duty to put somebody at the scanner and scan and scan and scan and scan and scan just so you can upload it and send it to the auditor who's in a different city. Okay, there is no requirement that a taxpayer does that. All right. Why does it matter? Like we said, it's very common, what I've found, it's very common for small businesses to keep records in both forms. And often, if you have physical records, they're not electronic. Electronic records aren't physical. So that's a very common practice, especially if you have smaller retail stores that maybe they have an old point of sale system that doesn't integrate with the rest of their accounting system. So they have daily receipts that are then keyed into their system or however they do it. I mean, I've seen all kinds. And in that situation, the physical records may be the only evidence that is there for an audit trail. I'll give you an example. I had a client. I'll keep this general, so to protect the innocent. I had a client who was in the middle of an audit, obviously, and their system. Well, an issue was how the receipts were printed for the customer, okay? That was the issue. That was one of the big issues in the audit. It was how the receipt looked when the customer got it, because one of the issues was what was represented as tax and what was represented not as tax. And if you practice in this area, you know that even if you're collecting and remitting the right amount of tax to the department, if you have another charge on the receipt that is mistakenly labeled as tax, and the customer gets it and it's called tax, even if it's not, even if it's a separate charge, and even if you're doing everything right otherwise, the department can take the position under the statutes and regs that mislabeled amount is tax, okay? So that should have been collected and remitted to the state, all right? So it's a pretty unique situation, but that's why it mattered what the actual receipts that were given to customers said. Now, my client had copies of those receipts, but not electronically. And it makes sense that they wouldn't, right? Because what you have on the back end is a point of sale system that just collected all the numbers, right? But what mattered was what the receipts looked like. And those receipts existed. They existed physically at the taxpayer's location. But you had an audit that was taking place with the auditor was in another city, and they did not want to come to my taxpayer's location. So we got in a real scrum, if you will, about what the department could and could not do in that situation when we were making those records available and they didn't want to come see them, okay? So that's an example of the conflict that can arise here. That's an example of the conflicts that can arise. And when you get into those conflicts, it's really important that you are papering over what documents are being requested and what documents are being made available and the circumstances that all that was happening. Because if a taxpayer does not make its records available to the department for an audit, that's when the estimate authority comes in, okay? So let's talk about estimates. Let's talk about estimates. Let's talk about guesstimates. So records are directly tied, as we've said before, and as it says there, to the department's ability to assess tax based on an estimate. What's an estimate? An estimate is an assessment against a taxpayer using the best information then available to create that assessment, okay? Like we said earlier, even information that's outside of the taxpayer's books and records. One of the well-known campaigns that the department has undertaken in previous years, and I'm sure it's still ongoing in one form or another, is audits of convenience stores that were where assessments were made based on data that did not come from those convenience stores. It was coming from the amounts of alcoholic beverages and tobacco that their wholesalers were reporting to the Department of Business and Professional Regulation, DBPR, for the tax on those wholesalers, okay, which is administered by DBPR. So you had wholesalers that were reporting the amounts of their deliveries of alcohol and tobacco to various customers, and obviously convenience stores were among those customers. And the Department of Revenue was getting that data, and then in an audit of, let's say, convenience store X, the department would pull that DBPR data, which was reported from wholesalers, and compare it as evidence of what was delivered for sale to convenience store X, okay? And the department had a formula that they would apply to say how much their markup should have been and how much tax should have been collected and remitted, and that was the basis of an estimate, okay? Now, let's set aside whether that was a good strategy, a bad strategy, an indifferent strategy. Kind of doesn't matter for what we're talking about right now. The point is that the authority for the department to even undertake that exercise is 212.12.5b, which is the department's ability or authority to assess tax based on an estimate. Now, if they're going to do that, though, there has to be a predicate for the department to engage in that estimate exercise. And that predicate is that the taxpayer has to have not cooperated with the department, okay? I gotta underline that in red, like it is on this slide. The statutory authority for an estimate only kicks off when the taxpayer has been uncooperative. And this is a quote from the Lloyd Enterprise case. You got the citation there, so you're welcome to pull it and peruse it at your leisure. So this is where I get the term guesstimates. You can see it there. I'm pointing, you can't see where I'm pointing, but you can see it there. To assess by guesstimates based on selected data and to be afforded the presumption of correctness. And obviously the judge in flowery language is calling these provisions draconian. And what's key here, though, is that the estimate provisions don't come into operation unless the taxpayer has done something wrong, like hid records from the department, like not complied with their record keeping responsibilities, like not allow the department to look at their electronic records that they're keeping, okay? That the taxpayer hasn't given access to the physical records that they keep, you know, on and on and on. It has to be something like that. It cannot be, like in the case of my client that I set up earlier, it can't be the fact that, well, the taxpayer has these records, they're in a physical form and you can come look at them, but the auditor doesn't want to come look at them. That is not a statutory authority for an estimate, okay? So you see why this is important. This is critical, because if you get a situation where this is happening, you've got to be able to push back, okay? So this is effectively a trap for the unprepared, all right? And just like I said, in the example that I gave, you may have an auditor that attempts to do this. Now, I want to flag something here though, okay? This situation that I'm describing for you is not a criticism, is not a personal criticism of any particular auditor or of anybody at the Department of Revenue, okay? I'm not in the business of throwing bombs at the Department of Revenue just because, all right? That's not what I do. I just don't. I think it's the wrong thing to do, and I don't do it, all right? But it is the case that it's a fact of life that the department's statutory authority to do estimates, to engage in estimates, is not well understood. And auditors are people too, and they're under a lot of time pressure, especially with the decisions that came out a few years ago that significantly prescribed the time limits within which a notice of proposed assessment, or a NOPA, could be issued without causing a statute to clip under Florida law. And we're not going to talk about statutes and NOPAs right now, but if you work in this area, you know what I'm talking about. And I've written about that before. So you've got auditors that are under a lot of time pressure and will sometimes skip steps. That's human nature. Though it is human nature, you've got to be prepared to push back. And if you're not prepared to push back based on the statutes, you know, if you jumping up and down and stamping your foot because you think it's wrong, that's fine. But you have to have a legal basis for your position in order for it to hold water. Okay, and you can't expect the auditor supervisor to take your side because of whatever. All right, you need a legal basis to make that argument. And this is frankly, this situation came up multiple times, which is why we had to dig into this in the first place. I mean, this, the Florida Bar Journal didn't come from nowhere. The Florida Bar Journal article didn't come from nowhere. It came from us having to work through these issues and push back hard when it was needed. So let's talk about some practice tips here. What I've done, and this is just good practice anyway, but you know, when you're in an audit and you have a good relationship with an auditor, at least initially, it can be easy to overlook some things because you get an agreement, whatever. But you've got to insist. I think you've got to insist that all document requests be reduced to writing, even if you agree to them orally. Okay. I find email works very good for this. Email paper trails work really well. And so I want all document requests to be in writing from the department to me. I respond to document requests in writing. I keep the paper trail. If I'm producing electronic records, what we'll often do is create a file that we then send a secure download link to. So I've got a folder that's organized exactly how I know the department is going to see it. So we're all on the same page. Okay. And that stuff, like it says there, can be dispositive in proving that the taxpayer did nothing wrong if you get a situation where an auditor, for time pressure purposes or whatever, is insisting on an estimate. All right. So that's estimates. Now let's flip over to sampling. Okay. This is less of a fireworks issue than estimates, but it's important, and it's important to know what you're dealing with when you're dealing with sampling. So sampling is assessing tax, the department obviously, assessing tax or giving a refund based on something less than a taxpayer's entire universe of records, okay? Now, the important thing, and this can be glossed over, all right, this can be glossed over, but it's available in two situations under the statutes, okay? When the taxpayer's records are inadequate, all right? And when the taxpayer's records are adequate adequate but voluminous, all right? You got the statutory citation right there. So let's talk about these. So what's inadequate records? Inadequate records is records that are not adequate, right? And you remember our discussion from earlier about what adequate records are and are not, all right? So adequate records, we got the accurate, inclusive, authentic, and systematic standard, which again is qualitative and directional, but there you have it. I should note that when it comes to sampling, oh, actually, I'm gonna get to that in a minute. Yeah, I'm gonna get to that in a minute. Okay, so adequate records, inadequate records, that's when you can do sampling. And it makes sense, right? Because if your records don't meet the adequacy standard, then that means you're gonna have records here, there, whatever. Some periods are gonna have, some months you're gonna have really good records, some months you're not. It makes complete sense that if records are not adequate, that you can perform a sampling of such records so that you can make the assessment. It makes sense. Now, adequate but voluminous records. When your records are adequate, but there's a whole lot of them, this is a much more normal situation. In Florida, obviously, we've got a lot of, well, we're dealing with sales tax. Yes, most audits are dealing with sales tax. It's by far the most prevalent tax in Florida. So in any audit, it's probably, I mean, 99 out of 100 audits are going to be sales tax audits, all right? So if you're doing a sales tax audit, that means you're probably auditing a retail business. And if it's a retail business, that probably means they have a high volume of sales. So if you have a high volume retail sales business with, or then nobody has time to sit down and audit every single one, all right? It would make zero sense for the Department of Revenue to have to sit and look through every single sale for a 36-month audit period when you have a high volume of retail sales. It makes complete sense that you would sample. Another situation, if you have businesses with lots of physical records and receipts. Go back to the example that I gave you earlier. That's actually what we were offering. We weren't saying, look through every receipt that we have. We were saying, let's pick some months and go look through them. But they still didn't want to do that, okay? So that's adequate but voluminous. Now, why do we care? Why do we care? It's always good to talk about why we care about something. So we care for a couple reasons. So sampling can be your friend. Sampling can be the taxpayer's friend, because if you're not sitting there and looking at every single receipt for every single day of every single month for a 36-month audit period, then it's going to be faster, right? And a simpler audit is a quicker audit. Quicker audit, less expensive than taxpayer time, not just lawyer time, but taxpayer time, because it is a rare taxpayer that has all this surplus time to deal with an audit. Because if you're a business, if you're running a business, you're spending your time running that business, okay? Especially with small businesses, they may not even have a CFO. They may outsource their CFO function to somebody else, a CPA firm, whatever. So there may be nobody within the company other than the business's owner that's dealing with this audit with you as the attorney. You know, maybe their internal, bookkeeper. I mean, that's a very common thing to have business owner, lawyer, bookkeeper, and that's it. So the quicker we can make this, the less expensive it's going to be in taxpayer time, okay? And going back to the lots of physical records issue, if you have a lot of physical records that have to be reviewed on site, let me tell you, I've never met an auditor that wanted to camp out really wanted to camp out in a business's back office for like a month. Nobody wants to do that. Businesses don't want that to happen. So if you can do a sample, everything can be faster. Maybe they come in and look for like one day. Maybe it's a small enough sample that even if it's physical records, you can bring it to the lawyer's office and have that review done there. There's a lot of options there if you weren't looking at every single transaction. But just like with everything, sampling is not always your friend. What if sampling is your enemy? Well, it can be, depending on what's in the sample. Okay, what I normally find is that is the two examples there. Is if you have let's back up. I'm not getting in deep on how a sample is done, but generally the department has a random month generator, if you will, in their computer system. So they will generate 3 months normally. So month 1, month 2, month 3 within the audit period, and then have 2 spare months, 2 spares. Okay. So you start with those 3 months that you're looking at. It's important to talk to your client about, all right, so we got these 3 months in the sample. Is there any errors you know of? Did you mess anything up in those 3 sample months? And was the mess up big enough and isolated enough that it doesn't reoccur over the whole 36-month audit period? That's important because what an auditor is looking for, and this is completely legitimate, okay? This is how it's done, and I think it is correct, is that you're doing a sampling to show what your error ratio is in your sample months, and then you apply that error ratio over the whole 36, okay? So if you have a big non-repeated error, like let's say you have, well, it doesn't matter what the example is, okay? You have error X, all right? And it's a big error, but it only happened once in 3 years. Well, normally you can negotiate with an auditor to either use a different sample month or to just exclude that transaction from the error ratio calculation. That doesn't mean that you're not going to pay tax on that problem, on that particular error, but what you don't want is for that error to throw off your ratio for the whole audit period. So that's what you're working for. Also with seasonal businesses, tourist related, I know we're all in COVID, but let's just pretend things are normal during the audit period. So you have seasonal businesses that go like this, when they're in season and off season. Well, if you have 3 off-season months that are being sampled instead of 3 in-season months, that's probably not great, okay? So you want, maybe 2 in-season, 1 off-season, whatever. But it's important to work these things out and work with the auditor to work those things out early on in the audit so that you can fix them. Here's another practice tip for you. Practice tip is to insist on a written sampling agreement. You won't always get one though. You won't always get one. And if I'm, frankly, and this probably rings true with most of you that do this work, is it's rare to have a taxpayer call you before an audit or right when an audit starts. Very rarely happens. What you have is a taxpayer that tries to work through it themselves, or a taxpayer and their CPA try to work through it themselves, and then something goes wrong along the way, and then you get a file with a NOPA and NOI and a bunch of work papers, and you got to try to figure out what went wrong. And it is very common for me to see those files when I get them, and a sampling was obviously performed, but there's no written agreement in there about what it was. There may be a note in the auditor's internal system about agreed with taxpayer to sample XYZ, but you won't have an agreement. So it's important to get it in writing, mainly so everybody knows what's going on, okay? So if you are sampling based on adequate but voluminous records, the department is required to seek an agreement with the taxpayer on what that sampling agreement will be about, okay? And they're required to try to get that agreement. So let's get that agreement in writing so everybody's clear. And like I said, when you get just an audit file and you're trying to figure out what the heck even happened, nothing is worse than trying to unpack what happened when you don't know what the sampling methodology was. You don't know what they were doing. Because an NOI the work papers behind an NOI are a notice of intent to make audit changes. Some auditors do a great job of being very detailed, very clear on what they did. Others, that's just how life goes sometimes. Okay, so get it in writing. The department is not required to seek an agreement if the records are inadequate. Okay, they're not required by statute, but in reality, do they tend to work with you? Yes, yes, they do. They will often work with you to agree on a sampling period. And this is a good way, like I say there, to handle records problems. Okay, so what happens? What happens then if the rules aren't followed? Well, it's very simple, and I said it earlier. If an assessment is a result of an improper estimate, an improper sampling, improper in the sense that the statutory predicates for either the estimate or the sampling were not followed, what happens then? Well, the answer is that the assessment is vulnerable to challenge on that very basis. And you have some cases there. We talked about Lloyd Enterprises. We've got some DOA cases there that also stand for this proposition. Okay. Now, of course, if you have an assessment that comes out that's the result of an improper estimate or sampling, normally you're going through the informal protest process, so you wouldn't have a published case. But that's where you would bring it up to the informal protest process at technical assistance and dispute resolution, and hopefully you can work it out at that level. And I found that when this kind of thing happens, technical assistance is understanding about the problems with the assessment. Practically, though, it may not be enough for you to point out that the assessment itself was improper in one way or another. You may also need to show something that shows that the taxpayer did their taxes correctly. You know, and what I found to be helpful is that if you have a taxpayer where, well, let me just say that everybody makes mistakes. Almost everybody makes mistakes. It's a rare audit to have a zero come in, at least on the audit side. So there'll probably be something wrong. And what I've found is that if you have an assessment that's based on an improper estimate or an improper sample that goes against the taxpayer, if the taxpayer, through the help of its CPA or what have you, can put up what they think of as a real number, what their real liability might be, then that can go a long way to resolving the situation. So my takeaways for you today, and we're going to look at see if we have any questions in a moment, is to advocate for your clients to keep physical records. You got to do it. You got to do it. You can't just let it go. Okay. You got to make sure that the rules for estimates and sampling are followed correctly. All right. And the first step is to understand them. So don't take this PowerPoint for gospel. Go and look at the statute, read it, highlight it. It's not exactly simple, but if you read it enough, you'll get it. And then you can insist that it's adhered to correctly. And if mistakes are made, as we said, use them to challenge that assessment. All right. So, Sheridan, I'm going to ask, should I stop sharing my screen in order to see what the comments might be?
If you click the chat feature, we had a couple of questions here. The first question is, do you know if the current legislative session is proposing an update to require taxpayers to maintain and or provide electronic records?
I confess that I don't study the legislation that's in process. I know that at the recent liaison meeting, there was a mention by French Brown, who was doing that part of the presentation, of something regarding electronic records. But I confess I have not studied that. I tend to not look at the legislation until it's passed. It's a little bit frenetic to try to understand something to look at, read, and understand something that might change tomorrow. So I tend not to do that. So I'm confessing my ignorance.
Um, Next question is kind of longer.
Sure.
It says taxpayer is owner of commercial building, sole tenant is related company owned by the same owner of taxpayer. DOR sends letter asking for commercial rental tax returns. Company fails to respond. DOR issues estimate assessment letter but doesn't follow up on collection for several years. Taxpayer then hires an accountant who prepares and files sales tax returns for the entire audit period, 44 months. DOR cashes the checks but refuses to assess the sales tax reflected on the 44 returns and will not abate the difference between the estimate and the actual taxpayer's forensics. They say that the statute expired, so good luck.
Sounds like you got a refund claim. I would file a refund claim. because that's 3 years from the, this is not legal advice, not legal advice, okay? But if you remitted the tax, then you should have 3 years from the date of payment. Um, I know there's that, I can't think of the name of the case right now, but it stands for the proposition, I say it stands for the proposition that if you pay part of of your total liability, that like you can't pay $1 of your liability and then file a refund for that dollar and then contest your liability. That's what I think the case stands for. Other people have said, taken the position that it stands for the fact that you can't have a liability that's determined against you and then pay it and then file a refund claim. I don't think the case says that, but that's probably the only option that's out there. Or if they try to collect against said company, then you have your collection defense options, if you will, and you can attempt to raise them there. That's what I would do. Not legal advice. Do we have more?
Yeah, Michelle Wynn says, have you ever dealt with a case where TP offers DOR login information to obtain records directly from Etsy, Amazon, etc., where DOR contested the Excel spreadsheets pulled from those records? Here, the DOR created an estimate because they did not agree with the Excel worksheet and contested that they were not third-party records as requested.
I wouldn't let the Department of Revenue log into your system and then snoop around. Um, I would use every procedural mechanism at your disposal to fight that. I would fight that on the water. I would fight that on the beach. I would fight that on the land because that's silly. I think you have somebody digging their heels in that shouldn't be. So I don't know procedurally where that situation is, but I wouldn't accept that.
Yeah. The previous question added a comment. He said that he didn't want a refund, just for them to accept the sales tax that they computed.
I think your options would be dictated by what the department is doing. If they're taking collection action, they're filing a warrant. You can challenge that. That might be the best way to handle it. But again, your procedural remedy would hinge on what procedural things are happening. So I think I've reached the limit of my non-legal advice on that issue.
All right. Do we have any more questions for Steve? Going once, going twice. Okay.
Sold.
Yeah. Steve, if the listeners want to get a hold of you, what's the best way to contact you? Is
Right
it by
there.
email?
Yeah, right by email. My email is right there. You can find my V card and other contact information at the firm website, which is osley.com right there.
All right. Perfect. Thank you, Steve. Uh, if somebody asks, can we get the slides by direct message? I think they have to email you, right, for the slides?
Yeah, just please email me and I'll shoot you the slides. No problem.
Yeah. So if you didn't get it at the beginning, the course code is 4333. So that's 4333. It's going to be emailed out to all registrants at the end. And with that, on behalf of the Florida Bar Tax section, thank you, Steve, for presenting. And we'll see you in the next one. Have a wonderful day, everybody.
Thanks, y'all.